So the way that this is going to work is that we have index cards that have questions on them. They're on that front table. We've got quite a few already, and what will happen is we have a timer. Some of the questions will be 3 minutes, 2 minutes, 1 minute in response. And Diane is our Vanna White. And you can see when it says 0 and a line through it, you're done. Give up the mic. 30 seconds, 1 minute, and 2 minutes. So hopefully if you don't need glasses, that's a good thing. And I need to thank some people who have been instrumental in helping getting this going. Lynn Beautiful brought the drinks, and we have had David Bunch do the posters. We have had Janet and Diane both be our Vanna White timer. Nancy got in there at one point in time. We've had Dan Lindgren help videotape, and thank you very much. And the proceeds tonight will be uploaded to YouTube. And my problem was that I had a user error, and so we've got 2 forms that are a little late being uploaded, but hopefully they'll be uploaded this next week or 2 before the ballots come out. And I'd ask that everybody hold your applause until the end, and that we don't have the conversations out in the audience so that everybody can hear what's going on up here. And let's see, what I'll do is give you 3 minutes to introduce yourself and give your background. And you're stuck sharing a mic with me. Okay. So if I grab it, it's because I want to talk. Go ahead.
Okay. All right. Good evening, everybody. Thank you for being here. I want to say, first of all, it's really good to see this much interest in politics, in local politics. I'm very encouraged by that. So,
your mic isn't on. There you go.
There we go. How's that? Is that better? Okay. All right. So I'm David Mistachkin. I am one of your 3 Superior Court judges for Grace Harbor County. I've been in that position for 6 years. I was elected first in 2018, and then I was elected again in 2020, and now, of course, I'm running again for another 4 years. I went to law school at Willamette in Salem, Oregon, and then I moved up to this area, to Grace Harbor, and I was an associate and partner at the law firm of Ingram, Zelasco, and Goodwin, pretty well-known firm. I did predominantly criminal defense and family law. And the reason why that's important is because those 2 areas of practice are about 90 to 95% of the work that we do in Superior Court. So it was kind of a natural fit for me, kind of a natural transition to the bench. I also was district court judge for 2 years as well. So in addition, I pro tem'd, meaning I stood in for sitting judges in courts all around the county and in other counties as well. In fact, in my legal career, I've practiced, I would say, in a number of counties, Pacific, Mason, Lewis, Thurston, Cowlitz, Clark. I've been pretty much all over the state when I practiced law. And I've learned a lot, had a lot of good role models too. The judges of Grace Harbor Superior Court that came before me, Judge Brown, Judge Godfrey, Judge Foscue, Judge McCauley, who I took over for, all excellent, all outstanding. They were certainly influential in my coming up to the bench. So, a little bit about me. I have a family. My wife, Nana's in the audience, my daughter, Catherine, and I have 5 other children, believe it or not. I have my hands full. Yes, that is correct. So, I live in Montesano. I can literally bike my way to the courthouse if I need to or want to. I love Montesano, and I love Grace Harbor. I've raised a family here. I've owned small businesses here. I've been obviously in private practice here. And I look forward to continuing my work in Superior Court. And I'm just going to tell you real briefly before my time is up, big picture, my number one priority in sitting on the bench in Superior Court is to promote the community's faith in the system. That's been my number one priority from day one, and it will continue to be my number one priority. That's something that I have emphasized, and I will continue to do so. I hope that you will vote for me. Thank you very much.
And I apologize, I'm normally not remiss in introducing our guests at the forum. And this is for Judge Position 3, Superior Court Judge. And David Mistachkin is the current presiding judge. And Stephen Jackson is the Chief Criminal Deputy Prosecutor, if I didn't get that incorrect. And he is running for the same position. And now it's your turn, three minutes.
Thank you, Gina. Is it easier to stay seated so then you're not up and down and moving the camera?
Whatever is comfortable for you.
All right, thank you. My name is Steve Jackson, and I'm running for Superior Court Judge here in Department 3. I've been a public servant for 24 years. I've been a prosecutor for 17 years. I started as a public defender way back, and that was instrumental to me understanding and learning about the criminal justice process, the various systems which are in place which attempt to rehabilitate or attempt to incarcerate, whatever it may be, those that become a part of the system. Currently, Gina mentioned that I was the chief criminal deputy. I was chief criminal for a period of time. I stepped down in order to kind of continue with the efforts of this campaign. Tonight I'm here with my dear wife, my stepdaughter, and my dear friend Crystal. We come here today and we come very humbly and are grateful for the opportunity to speak to all of you and to speak to those that will see this online. It's the third time that I've come out to Ocean Shores since this whole process has started. Second time I've been in this building, I spoke to the Northern Republicans women's group here, which was a wonderful event. Came out earlier in the year when I first met Gina, and I was a part of, I got to witness Ocean Shores Community in action, and it was impressive. It was a town hall type of meeting where the community came out and talked about their acute care concerns. And everyone was so involved and informed, and I just appreciated that. And throughout this whole process of going around the county and talking to different groups, that's what I'm impressed with. I'm impressed with the investment of the citizens of Grays Harbor in trying to help and better their situations. And so I humbly come to you today, and I want to do that as well. I believe that I can do a very good job. I think I can do a better job than the incumbent, my opponent. Thank you. I think one thing that's been just, I've been continued to receive the support over time. I think when this all began, this was kind of like, oh, this is cute. Steve Jackson's running for judge. It's not cute. It's not cute anymore. This is serious. I'm doing my best. Every day since this has been going on, I've received continued support, whether it be through signs, people's questions, people's support. People have shown up and continue to show up. And so that's what I appreciate in the process. I appreciate the give and take. I'm willing to give my life to the bench in Grays Harbor County. I humbly want to be the servant. I want to serve all the participants within the criminal justice system. And I look forward to doing that. Thank you.
We'll start with Steve first. Why do you want to serve or continue to serve as judge on the Grays Harbor Superior Court?
Thank you. Well, when I graduated from college, I kind of was wondering what, like we all do, we wonder what we're going to do. And I realized I knew I wanted to help people. Initially, I was going to become a social worker. And that didn't work out. So I was like, I'm going to become a lawyer. No idea really understanding what that meant. It's a marathon of a process. But I became a public defender, and I became a public defender in order to try to help my clients. And throughout the process, I realized that, unlike my opponent, I'm not geared towards being a defense attorney. It's very important. Certainly, defense attorneys, a good defense attorney is incredibly vital to the system that we work in. Everyone deserves a good public defender. But for me, it didn't resonate. I became a prosecutor, and I've been a prosecutor for 17 years. My foundation is law and order. I work with police officers every day. I have their support almost universally. I work with victims every day. Victims, all the participants in the criminal justice system in court deserve to be respected. They deserve time, they deserve to be heard, they deserve their pleadings to be read. And that's what I intend on instilling, kind of turning back the page a little bit. In Grace Harbor County, there's an old energy. And I'm not saying it's a bad energy, but with the new judges we have, with Judge Svoboda, with Judge Samuel, who have both endorsed me for judge, and I don't know if everybody understands that. There are 3 judges. Mr. Mistachkin is one of those judges. The 2 other judges that work with him every day have endorsed me, in addition to both of the political parties. I think that speaks volume. I think it speaks to, really, if there was a vote of no confidence, that's it. So when I take the bench, I will give people their time. I will hear what they have to say. I will respect the victims. I will respect all the participants. Nobody wants to be in court, really, whether you're a defendant, a victim, a family member of either of those, a juror. I mean, thank you for all when you come to court and you do your jury service. We all appreciate that civic duty, but nobody really likes it. Paying a ticket, getting a no contact order. Court's a rough place to be. If you're gonna go to court, you deserve to be respected. You will be respected in Department 3 when I'm the judge.
And you drop 2 cards on the floor. Go ahead.
Okay. All right, so I think I'm going to stand if that's okay. I'm more comfortable standing. That's all right, not to be difficult. All right, so, I'll tell you, I have enjoyed this work tremendously. That's the first reason. I have enjoyed it. I've been a judge for 8 years, and I've had a lot of good mentoring. I've had a lot of judges that I've conferred with. I go to judicial conferences and meet judges all over the state, and in fact, I've been to national conferences where I've met judges from all over the country. And, in my legal practice, my law practice, I was a litigator. I did criminal defense, family law, I did some civil. I had a pretty wide base of experience. I also, when I was an attorney pro tem, I was invited by many different courts to actually be a sit-in judge, a fill-in temporary judge. I have quite a bit of experience. I can't necessarily say that for my opponent, who has never served in a judicial capacity ever, anywhere, at any level. He also hasn't practiced any civil law or family law. He's pretty much had one role, prosecutor, and that's fine, that's valuable, there's no doubt, but the system itself, Superior Court is much bigger than just being a prosecutor. We have to hear and entertain a wide variety of cases and different matters, and so I think my experience and my qualifications speak for themselves. And if you look, I'm not a big fan of endorsements. I've seen this before, where candidates will come in and say, hey, look at this whole list of people who are endorsing me. But that doesn't really matter. Endorsements are only impactful if they're meaningful, if they're people that are from this community, people that are invested in this community, people that know the community. And if you look at my endorsements, they're not just one-liners. They're detailed description of their experience with me, why they're endorsing me, why they think I'm the best fit for the job. Those are meaningful. And I would encourage everybody, if we're going to talk about endorsements, which I don't think is the most important thing. This isn't a popularity contest, right? This is about qualifications and experience. And my experience speaks for itself. It far outweighs the experience of my opponent. It's not even close. So the reason why I think it's important for me to remain is because I want to continue the work that I've done, really with a couple of things. I want the court to be more user-friendly. That's the first thing. And I also want to make sure that everybody, and this is the #1 priority for me, that everybody that comes into court feels like they got a fair shake. That's ultimately, because that promotes the faith in the system. If people can come to court, win, lose, or draw, if they know the reasons for the decisions, they get it explained to them in a nice, polite, respectful way. That's what it's all about. That's good for the system, and I believe I'm best for Grace Harbor Superior Court, and I urge you to vote for me. Thank you very much.
Well, since we just talked about endorsements, and I'm sorry that you don't think that they're valuable, but what's the one endorsement that is the most important to you?
Well, I guess the one, it's tough because, and I don't minimize endorsements, my goodness. I am grateful for the endorsements, the people that are willing to have the courage to come out and say that they support what I'm going to try to do, support this campaign, support the energy and efforts and goals. That's very important. And they are members of our community, despite what Mr. Mistachkin will say. These are police officers. These are officers that are serving our public every day. These are the two, so I'm bipartisan support, so I have both parties' support. This is a nonpartisan race. It doesn't often happen where non and bi come together in such a fluid way. It really does here, because it's nonpartisan, meaning that politics are not a part of it. But both parties, despite that, have come together. When do we see that happen? Very seldom. I mean, in my life, I've seen some bills that have been bipartisan. I can't recall a candidate that has ever been bipartisanly supported. It doesn't happen. So, single one, it's very difficult to pick one. These are all people that I value that apparently are wishing that I am successful in this campaign. But I think singly, if I had to pick one, it would be the endorsement of both parties, because this is nonpartisan and with bipartisan support. Just regarding the last question too, I would just note that being a prosecutor, under the rules of professional conduct, I have to seek justice in every case. So I am quasi-judicial under the rules. I act as a judge. I am the gatekeeper before the case goes to a final decision by the judge. I represent and protect the defendant's rights. I look out for the victim under the Victim's Bill of Rights in our Washington State Constitution. I protect the process so that jurors are presented with a fluid jury trial. So I am the gatekeeper. Before anything hits a judge's bench in a criminal matter, it comes through me. I've done it for 17 years in thousands of cases. I am quasi-judicial by its terms as a prosecutor. Thank you.
I'll go ahead and stay seated then. Let's do that. All right, so I want to just say one thing. I didn't mean to suggest that endorsements aren't valuable. They are. I think what I was trying to say was that it's how meaningful are the endorsements, it's how detailed they are, and are they local? The fact is that my opponent, a majority of his endorsements are from people that don't even live here. They're from California, where he came from, or Yakima. They're not from Grace Harbor, but that's okay. The point, I guess, is that people that have been in this community. So if you look at, say for example, community members like Bruce and Betty Worth, for example. I don't know if anybody knows them, but Dr. Worth was a longtime doctor on the harbor. He's been here. He's a longtime harborite. He's lived here for his whole life and was a doctor and had a very thriving family medicine practice in Aberdeen. Him and his wife are outstanding. They are very involved. I've never seen two people more involved in the community than Betty Worth. They endorsed me. And they gave me a meaningful endorsement where they explained all the years of history that they have with me, how they've observed me, how they've watched my work. I've also been endorsed by many lawyers, the lawyers that have been around a long time. And so I think it's important to be critical when you look at endorsements. That is very, very important. Also, I want to point out that I did not seek either endorsement that Mr. Jackson is referring to. I didn't seek the Republican endorsement, and I didn't seek the Democratic endorsement. And I'll tell you why. Because judges are nonpartisan. We have strict ethical rules, and we're supposed to avoid partisan politics. And Mr. Jackson appears to really have a taste for partisan politics, and I just can't get there. I think it's important for a judge to be completely neutral, and I have purposely gone out of my way not to affiliate with any highly partisan organizations or individuals, because that creates controversy. And controversy is bad. As a judicial officer, we want to have a completely blank slate, so when someone comes in front of me on a case, they don't want to have to wonder if they're going to get a fair shake because I endorse the opposite party, or because I'm affiliated with the opposite party. That's not okay. That's a misstep, and I have more integrity than that, and I will continue to exercise that discretion and that integrity in not pandering to political parties and individuals to get meaningless endorsements. I will continue to do my work, and I will continue to serve the citizens, but I will do so in an ethical manner. Because quite frankly, having integrity, maintaining these principles of neutrality and being unbiased and not affiliated with groups or individuals, that's what promotes people's faith in the judges. That's what it's all about. Thank you very much.
David, this is for you first. What are the most important things you use in making your decisions when the evidence is not clear?
Well, that's a really good question. So, not to toot my own horn, but judges do have a very difficult job, I will tell you. So, there are obviously laws, and it depends on what kind of case we're talking about. So, you got obviously criminal cases, everyone's familiar with that, right? Proof beyond a reasonable doubt, and all that. So, in criminal cases, the law is pretty clear. And in a lot of cases, we're not making those decisions. Juries are usually making those decisions, the vast majority of cases. But in the civil realm, where we have, civil litigation, family law, right, which is probably the main one. I did a lot of that as an attorney, and that's where we have people coming in, getting divorced, fighting over custody of children. There are certain legal standards that are already in place, and we're supposed to follow those. And so kind of the legislature puts us in a box. They tell us what laws to apply and what standard to apply, and all we're really doing is being a referee. That's what it's all about. It's about taking the facts that have been proven, applying the law, coming to a decision. And there are some cases where it's a really close call, and that is something I take that's where experience comes in. I mean, I keep coming back to this, but experience. Someone who doesn't have any judicial experience is at an extreme disadvantage in terms of making those difficult calls. I mean, they just are. There's no substitute for experience in this position. There just isn't, to be perfectly frank. So my 8 years on the bench, and really more than that if you count my pro temping, but my years on the bench have really helped me. It's really helped me to analyze. I've seen so many different scenarios, so many different types of cases, different parties, different issues. I've seen the whole gambit. So, and I also was a judge in district court and municipal court. So I've been a judge in every level of court in the state. I'm also currently the most experienced judge in the county between all district court judges and all superior court judges. I have the most experience. I'm the senior guy somehow, believe it or not. And I think that's what it's about. That's the bottom line. You want somebody with experience that has a proven track record of doing the job and doing it well. So that's what I would say about that.
Well, this is just an interesting platform. I've never done this. I've never been a politician before. This is new. It's really, I'm apolitical if you get right down to it. Some of the insinuations, I'm not going to try to go to that level or use rhetoric which is necessarily inflammatory. But it's fascinating to watch a profile in action. A profiling action that talks about, doesn't want to toot his own horn while he toots his own horn. Doesn't want to face the difficult reality that the two colleagues that he works with are endorsing me. Brushed over that. If under this theory that he has, that there would be no new judges. You would become a judge by some act of somebody saying that you were the judge, and you would be the judge forever, because that's the way that judges work best. The longer they are, the better they are there. They know more, they have the most experience. If you're a lawyer, you practice law. And I would suggest as a judge, you're practicing law as well. Every day I learn something new. Every day I'm posed with something I have to look up, something I have to talk about with somebody, a friend I need to call, something I need to read about, so that I get to learn that. So that next time that comes across my desk, I know about that. That's practicing law. It's the same being a judge. You have to learn content. Subject matter is important, I'm not saying that. Family law, and I have done some other things. I'm certainly more of a criminal lawyer, no doubt about it. But I've done dependency actions, I've done delinquency actions, I've done some family law stuff. That's happened. Regarding the question, so I think it is important that the role of the judge is a neutral arbiter. It's not someone who creates a narrative in their mind based on emotional responses or some prior trauma or whatever it may be. It's not to imagine what would happen in my situation if I were that person doing that. It's not that. We can't leave who we are at the door. It's kind of like when a jury comes in. The jury system's so great because everyone brings in their own personal experiences. And as a collective, it forms this one unit which makes the decision. I can't leave who I am behind. But that being said, I am who I am. I'm going to take in who I am to the situation. But that doesn't mean I insert myself into a situation where I direct questioning. I want to examine the witness myself, though that's allowed sometimes. I'm not going to do that. I'm going to rule under the facts of the case. I'm going to remain impartial. And I'm going to apply the law. It's as simple as that. It's actually a very simple thing when you look at it like that.
Thank you. And do you have personal techniques to assist you in remaining neutral? Or how do you remain neutral?
For me, it's pretty easy. I'm the same person every day, all day. I'm not going to be a different person or rule differently because I had a bad night before, or someone said something to me which made me upset, or on the converse that, I feel really good today, so I'm going to rule differently. I come to meet everybody. For one, I think the judge's role is to hold space for the participants, to allow them to be heard.
How do you assist in remaining neutral?
Thank you. So I think I'm neutral to begin with. I think I come in neutral. I don't come in with a narrative. I don't come in trying to convince myself of what this person may be saying. I listen. I read. I'm posed with a set of facts. The law is established. So neutrality is not a difficult thing for me. It never has been. I'm not an overly opinionated person. I have my thoughts and beliefs, but I think everybody has the right to have their own thoughts and beliefs too. I'm not to exert my thoughts on somebody else. You come to court because you want to get something done, or you're protecting yourself from something happening to you. Tell me about it. I'm not creating a narrative in my mind where I've already kind of decided I'm thinking about what the next case is. Tell me, write it down, let me read it. I'll listen. I'm a good listener. I always have been. A lot of this is talking about like the roles, the experience, and I'm not saying roles and experience are unimportant. They're certainly very important. But character is very important. Who you are as a person, where you are in your life. I feel like I am ripe for this. I am ready. I've waited, I've put my time in, I've learned, I've listened, I've respected those around me, they respect me. We don't want to talk about the endorsements because the endorsements don't work for my opponent. Most of his endorsements come from the folks he used to work with. It's okay. It's fine. My endorsements do come from different parts of the state, different places. Maybe that shows that I've been the same person all the time. I haven't changed. I am who I am. I've been that person in Yakima. I've been the person in Grace Harbor County. Way back in California, I was that person. Those people hear my story and they're like, Jackson, yes, they're writing in. So read the endorsements, please. Yeah, I invite you to read the endorsements. Ask any police officer you know, ask any fireman you know, ask a social worker you know. Who would you vote for? Ask the people in your community. Thank you.
So that's, first of all, a really good question. Remaining neutral is a byproduct of two things. One, integrity, and two, experience. And I'll start with the experience. So the reason why that's helpful is because when you wear multiple hats, when you've worn multiple hats, that helps you be neutral because you understand it's just a role, right? You don't put your thumb on the scale of justice. Nobody wants that. And so when you have somebody that's one-dimensional, only has one type of area of law they've practiced, it's going to be more difficult. It's a challenge. It's certainly a disadvantage. In my practice as an attorney, I've pretty much handled every type of case that there is. And as a judge, same thing. So that helps. The experience helps because really coming in cold without the proper experience, it would be very difficult to wear that hat because it's a hat that you're not used to. Before I became judge, I had been judging on a temporary basis as a pro tem judge for years before I took the bench. So it's not really accurate to say that you never have experience when you become a judge. That's not true. In fact, many of the judges that are currently sitting had experience as a pro tem judge, like I did, before they took the bench. Very important. The other thing is integrity, right? So, it's one thing to understand the importance of being unbiased and impartial, but it's another thing to implement it and put it into action. And that's where integrity comes in. It's not about personal preference, right? As a judge, I'm not looking at what do I want the outcome to be. I'm looking at it from purely, okay, there's facts, here's the law, I'm making a decision. It's actually cold. It actually is very cold. It's not with consideration to play favorites. It's not with consideration who the parties are, where they're at. It's just simply, okay, what are the facts? What's the law? Make a decision. That's how you remain neutral. There isn't really anything special to it. There's nothing really to it except that, but it's as intuitive as it sounds, it's something that you develop over time. It's not something that you just start off with, right? It's like any profession. It's like any industry, plumber, electrician, doctor, lawyer, you name it, right? You don't start off doing a great job, right? You have to learn. And the years that I have, the years of experience that I have helped me get to that point where I can do that. And so the question really comes down to, do you want somebody that has all that experience, the years of experience, and is already doing that in that role, or do you want somebody that has zero experience and is going to be starting from scratch? That's really what this election and this race comes down to.
Diane, let's start doing 2 minutes at a time. Do you think the Washington State Commission on Judicial Conduct should discipline judges for free speech? What is your feeling about a judge at any level speaking or participating at a public event or at a rally that has political overtones?
Yeah, it's really interesting that you bring that question up because there was recently an example of that. So we had a Loggers Play Day parade. Maybe you're familiar with it. It's in Hoquiam, right? Happens every year. And you have a parade float, right? And you enter your parade float, and your parade float goes down the road. My opponent's parade float was flying a Blue Lives Matter flag on the back of their parade float, which to me, that's a no-no. The answer is, that's a violation of judicial ethics, 100%, no question about it. Affiliating with a political organization, a political policy, a political belief, anything like that is completely inappropriate for a judge. It's absolutely inappropriate. It doesn't matter what your personal politics are. That's really irrelevant, because as a judge, we have to give that up. Our rights end at we can vote, and that's it. That's the rights we retain as a judge. We give up everything else. We can't attend rallies, we can't be political, we can't take positions like my opponent who went on the radio and said, I like firearms and I like sovereignty. I mean, these are things that he has said, and the Blue Lives Matter flag is another example. He has shamelessly pandered to highly partisan politics, and it's really unfortunate. It really calls into question integrity. And again, it comes back down to integrity. Now, these are sanctionable offenses. These are things that the Judicial Conduct Commission would look at and probably sanction if he were a sitting judge. But I refuse. I refuse to do that. And if you look at my campaign, you'll see none of that. You won't see one. I challenge anybody to go to my campaign and find one single example of partisan politics. You won't see it. It's just not something I'm prepared to do, because my integrity is more important. And more importantly, the community members and their faith in me is more important. Because if they don't have faith in me, I can't do my job. Thank you very much.
So I don't know if it's going to be consistent throughout this evening, but it's certainly throughout my observations of Mr. Mistachkin as he's been on the bench. Talk about over-speaking, well, as he would say, 100%. These over-exaggerated generalizations and speaking as if it's so, when it's not. You know, if you say something 100 times, same thing over and over again, maybe somebody will believe you. Anybody here that thinks that I've done something, if I had done something wrong, that this gentleman wouldn't have done something about it or tried to do something about it, it's because I haven't done anything wrong. Blue Lives Matter, it was an American flag that had a blue strip on it. It was the trolley. I think he's got maybe float envy from this parade, because I had the gift of Dave Jennings bringing one of the old retired Aberdeen trolleys that had been kind of sold off a number of years ago. So he donated that for us to be in the trolley together. And then I had a vintage bug behind me. So I think it's unfair, really, to me to try to qualify that, or the fact that I talked about sovereignty. Since when does sovereignty become a political term? We all deserve human sovereignty. Since when do firearms become a political term? I believe in the Constitution, all of it. So be careful as you listen to my opponent. You're all smart people. I speak to you as I speak to a jury. You bring in your conditioning, your experience, and you'll come to a decision which is the right decision. And I know that decision will be to vote for me, Steve Jackson. Thank you.
Thank you. The Code of Judicial Conduct says that judges can't participate. Did I just skip you? Okay. I just looked at you and I thought,
Nope.
oh, okay.
I think we're good.
The Code of Judicial Conduct says that judges can't participate in extrajudicial activities that could lead to disqualification. How would you evaluate whether or not to accept an invitation to speak that might result in a complaint against you for such activities? And it's your turn.
Well, I guess it's interesting. It's like you can be invited to speak. It depends on what you're speaking on, and it's the nature of the particular event you would speak to. If it's political simply by its term and by its nature, then I would probably be more cautious about that. But in these types of situations where I've been invited to speak to these political parties, these are citizens of our county. The vast majority of them represent Republicans or Democrats. We're quite a purple county now. We've gone back and forth, but we're purple now. My goal in this was to get my name out there. Unfortunately, Mr. Mistachkin's got his name out there because he has been a judge. My name's not out there so much. If you talk to anybody in the court system, certainly they know me. Any police officer knows me. But I spend my time in the garden when I'm not at work. I work a lot. So discernment's important. When I've spoken to the Democrats, when I've spoken to the Republicans at their request, it's because I am seeking to speak to as many of the citizens in Grays Harbor County in order to get the message out. It's time for change. This election cycle is incredibly important. It's important for us on a national, state, and local level. And it's important for us in the Superior Court here in Grays Harbor County. And so I would use my discernment, I would use my wits. I wouldn't step too far into it, and I would avoid situations which are on its face inappropriate for a judge to speak out. Thank you.
For me, that's an easy answer. Just don't do it. And I haven't. And it sounds like what I'm hearing is an excuse. Like I had to do it because I have to do it to win. I need it to get votes. I need it to become more popular. I need to violate the judicial ethics. I need to engage in partisan politics. I need to affiliate with these organizations. I had to. I had no choice. That's what I hear Mr. Jackson saying. It's deplorable, simply put. I mean, it's something that if we were a Republican and Democrat and we were running for Congress, no problem, right? No problem. Totally typical, absolutely acceptable, no questions asked. But judges are different. Judges, and I invite everybody to look at this, and that's a very good question, and I know exactly where that question comes from. If you look at the Code of Judicial Ethics, it's very strict. It's very strict. And it tells us that we're supposed to refrain from doing anything, affiliating with anyone, any person, any organization, any law, any policy, any platform, anything. We have to avoid that 100% in order to remain truly neutral. And I think my opponent has lost sight of that. I don't say these things to disparage him. I run my campaign. I've run a clean campaign, unlike my opponent. If you look at my campaign, radio ads, events, social media, I haven't even uttered his name. I can't say the same for my opponent. He's badmouthed me with everything he said the entire campaign, and that's fine. That's his right and his privilege. It reflects poorly on his character, but it's certainly his choice to do that. I refuse. I refuse to do that. But in this particular domain, I have to say, that concerns me. When I hear somebody that's running for a judicial position get on the radio and talk about how they like firearms, and they believe in firearms, and they believe in sovereignty, which is certainly hot-button issues, not to mention the Blue Lives Matter flag. Those are hot-button issues. Those are purely political. They're highly political, and to think otherwise is just silly. Thank you very much.
Gina, we'll pause for just 1 second.
Yes. As an attorney, have you ever been the subject of a complaint made to the Washington State Bar Association, or as a judge, a complaint filed with the Washington State Commission on Judicial Conduct?
That's an easy one. No, I have not. I don't need much time to answer that. And I will tell you, too, just to kind of point this out, and I'm sure Mr. Jackson will back me up on this. As an attorney, especially a defense attorney, it's very common to get complaints. In fact, right? You think about it. So I'm representing people that were charged with a crime, and if they don't like the outcome, they got nothing to lose, right? They're going to complain. Of course, they're going to blame their lawyer, right? It makes sense. And yet, despite that, I never received such complaints. And I did criminal defense for 13 years without complaint. And I've been on the bench for 8 years without any complaints. So if Mr. Jackson's correct and I lack integrity, as he's been saying this whole campaign, and he's saying I'm making all these inappropriate decisions and using inappropriate basis to make those decisions, why has no one made a complaint? How have I gone 8 years on the bench without any complaints? I'd like to think people think I do a pretty good job, and I'm not tooting my own horn, that's my understanding of my reputation in the community. I certainly hope that's the case. And I do think I do a good job, and you know, avoiding complaints actually isn't that difficult. There are certain actions that have happened that can certainly get you a complaint. It's easy to draw a complaint if you're making effort, but it's also easy to avoid it too, and it's simple. It's above board. right? As long as you act above board and avoid bias, and avoid partiality, and avoid affiliating with inappropriate organizations and individuals, you don't have that problem. You don't get complaints. As long as you do your job, and you do it well, you don't get complaints. So I have never had a single complaint ever as an attorney or a judge, and I'm very, very proud of that record. Thank you very much.
Thank you. Steve?
It's an easy answer from me as well. I've never had any type of complaints at all. I was a public defender, and I liked being a public defender. But it reached a point, I was good at my job. I've always been good at my job. I work hard. But I became up to the point where I had to represent people that I didn't really want to represent. And I had 3 small children at the time. And I was being asked to represent sex offenders. They deserve to have good representation, I'm not saying that. But it was at that time that I made a philosophical change to prosecute sex offenders, primarily in the beginning. And I've continued that ever since. But my philosophy, when I come back to who I am, I lead with law and justice and public safety. I am a prosecutor at heart. My opponent is a defense attorney that wears a robe. And that's probably the most disparaging thing I've said about him. And if you look at you listen to my radio shows, you read my website, these 100%, these over-speaking that you're witnessing tonight, they're not representative of the facts. But if you say it enough times, then that's what it becomes. That some people believe that. So no complaints. I've always been praised and been given promotions, and I was asked to cover and become the chief deputy here to get the prosecutor's office through a tough period. So no, I'm a public servant, and I haven't had any complaints. Thank you.
How do you make, you were quick. How do you make sure both sides of a custody case are given full consideration, and how much weight is placed on the guardian ad litem recommendations?
So the guardian ad litem is basically akin to an arm of the court. They're appointed by the court. It can be through a court-appointed special advocate if the county has that type of program. But a guardian ad litem virtually speaks in general that they're going to get appointed to children. They can be appointed also to dependent adults who need a voice. But what that guardian ad litem does is they become the voice of the person that doesn't have the maturity or ability or presence to say what's best for them. So the guardian ad litem tells the judge and tells the parties what is in the best interest of this child or this dependent adult. And I think incredibly important, because the advocates for both sides in a custody battle, they're doing their job. And so it's important to listen to the presentation of their cases, but when it comes down to the best interest of the child, because that's what the guardian ad litem is really about. They're there just to make sure that that child is heard, that the judge knows what they want. They're the voice. And so where I have a situation perhaps that would be both sides are presenting their case and it's a tough call. You're trying to wait. You want to do the right thing for this family. You want to do the right thing for these children. You have to listen to the guardian ad litem. You have to listen to the voice of the child. And that's what the court system allows us to do, to appoint and then have that arm, have that voice directly to the judge. So I would weigh heavily a guardian ad litem position, certainly. They're not always lawyers. They can be citizens. They can be volunteers. They can be paid as well. Thank you.
Thank you very much. Yeah, so family law, wow, I don't even know where to start. I only have a couple of minutes, so family law is complicated. I've been doing family law my entire legal career, so I have, between lawyering and representing clients, both mothers and fathers, right? Both sides of the equation. Custody cases I've had, I've lost count how many custody cases I've handled as an attorney and as a judge. So in the last 6 years, I've handled hundreds. I mean, I don't even know how many, and they're excruciating. Custody is one of the hardest things, in my opinion. I mean, I always joke about this, so take it with a grain of salt, but I'd rather hear a murder case than a contested custody case. Custody is nasty business, you know, and it's further complicated by parents who often put their kids in the middle. That's another dynamic that we see very frequently. That's the point of a guardian ad litem, is to come in and be a neutral party who can come in and investigate, talk to both parents, talk to people that are involved with the children, and sometimes they talk to the child. Depends on the maturity of the child. And then make a recommendation. They're not always correct. Many times they are. But I think it's important. We're not just a rubber stamp. As a judge, we're supposed to look at all the evidence. And the guardian ad litem is just one piece of that. So we look at that, we look at all the other evidence, and we have to exercise our own independent discretion and decide ultimately what is best for the child. And I pride myself on that record. You know, I tell people all the time, you know, and it probably irks them, but when I have parents in front of me, parents that are putting the kid in the middle, and they're bickering, right, and they're trying to put the kid in the middle, and I say, look, I point at both of them and I say, I don't care about you, and I don't care about you. I care about the child. That's it. That's my job. I'm there to protect the child's best interest, period. That is the beginning and the end. And I act accordingly, and I make decisions accordingly. And do we get it wrong? Sure. Absolutely. I mean, I'm sure I've gotten it wrong before, but I'm conscientious and I try very hard to listen to all the evidence and get it right, because children's outcomes are at stake, and I take that extremely seriously. Thank you.
How do you view your role of judicial discretion in sentencing, especially when considering mandatory minimums or alternative forms of punishment?
That's a really great question. I don't have nearly enough time to explain that system, but because it's very complicated, but I'll do my best. So the legislature has tied our hands in a lot of cases, to be quite frank. The Sentencing Reform Act is a law that dictates to us judges what sentences we can impose, meaning we're handcuffed. In a lot of cases, we don't have any discretion, or very limited discretion. In the cases where we do have discretion under the law, I'm looking at a few different things. In terms of, so the basic principle is, am I going to put this person in prison? Are they going to prison, or am I going to try to rehabilitate them and give them some kind of alternative to prison? That's really the main thing that I think the question refers to. When we look at that, there's a few different things I'm looking at. Does the person understand and appreciate the wrongfulness of their conduct? Do they have remorse for their actions? And are they willing to address whatever the issue is that caused them to commit that crime? And in most cases, we're talking about mental health issues, we're talking about drug addiction, whatever it is, trauma that they've experienced as a child, you name it. There's all kinds of reasons why adults end up committing crimes. So I look at that, and for people, what a judge is supposed to do is ask, okay, what's best serves the community, the victim, and even the defendant? We're supposed to look at it as a total package. What sentence best serves those interests, right? So people, sometimes it's easy. People that don't want the help, that don't want to get drug treatment, that don't want to get mental health treatment, punishment's the only answer. That's it. It's really that simple. For people that do want the help, we try to do that. We try to give them an alternative to prison. But in some cases we can't because it's not safe. So for example, if someone's really particularly dangerous, if I've determined that they're dangerous, then I'm not going to put them back in the community. That's just not going to happen, because ultimately my job is to protect this community, and I do so on a regular basis. Thank you very much.
So with less and less money that we have in the system available to either usually rehabilitate people, you have to make decisions. You know, sometimes everyone can't get a sentencing alternative. The fact is, though, since I've been in Grays Harbor, and you know better than I probably, but my observations are that the people that are born here, they live here, they may commit crime here, they'll often die here. They'll raise their families here. What can I do as a judge in order to stop whatever was the precipitating cause of why this came to court? What caused the criminality, right? Was it mental health? Was it substance abuse? Was it anger management? Was it domestic violence? What was it? What tools are available to the judge in order to prevent recidivism? Because the goal of the judge in a community, I would suggest, like this, where it's kind of insular and we see each other throughout our lives together and we watch families raise their children and those children become adults and have children, the cycles of different, whether it be substance abuse or mental health. So you use the tools you have in order to try to prevent this possibility of future criminality. You can't always do it. But when you can, you do your best to do it. If there's no other option and you have to send someone to prison, you warehouse them. It's unfortunate, but sometimes you have to do that. And certainly looking at things differently, whether it be a violent crime, a crime against person, or a crime against property. Not to minimize crimes against property, but we're required to look and pay more attention to, especially in regards to public safety, crimes against people. So we do what we can, we use the alternatives when they're available, and we incarcerate when we need to. But bottom line is we do whatever we can to prevent that future possibility of crime being committed again.
Thank you. How would you describe your judicial philosophy and how does that influence your decision-making process?
Well, it's kind of just what I was just talking about. I think in every case, certainly every criminal case that comes before me, I'm going to be looking at, all right, where are we at for this individual that's caught up in this conduct that has enveloped other people, usually a victim of some type, and the citizens of our community? How can we address it in a fashion that will prevent that from happening again? So the philosophy is always to come fresh to every case, look at the facts of the case, look at the person's history. What can the bench do in order to try to prevent citizens of our county either being harmed, their property being harmed, or their person being harmed? So it's always going to be approaching it from an open position where you're willing to listen, you're willing to look at the history of the person, and then do whatever you can to prevent that from reoccurring again. So always the goal in criminal court should be, whenever possible, is to prevent them from coming back to court under these circumstances. Generally, the philosophy of the judge should be to listen impartially to every case that comes before, truly impartially, and attentive listening, and reading what the lawyers write. You know, it's fascinating in criminal court, you know, we have to do sentencing hearings sometimes, oftentimes, and we have to write a sentencing memo. So sometimes because court's really busy, right? So I write a substantial sentencing memo so I can let the judge know what's going on, and I won't have to talk, and we can move on through the cases and process the very many cases we have. Mr. Mistachkin says he's prepared, but it becomes abundantly obvious that he's not when the questions that he gives to the attorneys are reflective of not having read the material.
Thank you.
Well, but before I answer the question, I'm going to start with that last statement. And the reason I'm going to start there is because that is a perfect example of what I've been talking about. So that comment he just made literally violates judicial ethics. It violates the canons of judicial ethics, which dictate and state explicitly, thou shalt not impugn the integrity of a judicial officer or decisions they make in the court. He's violating that directly, and he knows he is. He's pretending like he doesn't know that, but he must know that. At least he's presumed to know it. So that's a little bit disconcerting. And it's also interesting that he doesn't point to an actual example of that. So he keeps saying all these generalities, but he doesn't point to any examples of what he's actually talking about. But I'll leave that alone. My judicial philosophy is simple. Due diligence and transparency. Those are the two key components. And when I say transparency, I think that's probably the biggest thing. Judges, and I've seen this, and not all judges are built equally. And so some judges, in good faith, will sometimes give less explanation. They'll just make a decision and move on, right? And there's a lot of pressure to do that because it's built into the system. We have limited time, right? So for example, on Monday, I had 30 cases I had to get through in a couple hours, and they're complex cases. And so there is a pressure to be fast, but I put that aside because for me, the top priority is transparency. I always, in every single case, want people to know why I ruled the way I ruled. I give analysis, I give detailed analysis, and I give my reasons, and I explain the reasons. So people, even when they lose, at least they feel like they got a fair shake. The other one is due diligence, and that's just experience, is what I mean by that. Doing your work, doing your homeworks, knowing the law, putting it into practice, and that comes with experience, years of experience. That's something that you don't start off being good at doing. I mean, that's just the reality. Thank you very much.
I've got lots of cards here, and some of them are kind of duplicates, so I'm trying to go through them as you speak, and I'm sorry if it looks like I'm not paying attention. Sometimes I'm good at multitasking. Are you open to implementing a new program for violence prevention that anyone who is arrested or convicted of a crime related to violence, especially domestic violence, that they be required to attend an intensive treatment that is modeled after drug court? Go ahead.
Yeah, that's actually a really good question. So I don't know if everybody's aware, but I was actually the therapeutic court judge for 3 years. In fact, Judge Brown, you may remember, he was the pioneer. So he started it started in 2018. It was just drug court. I took over in 2019 and was on therapeutic court for 3 years, and it's amazing. I mean, it's a great program. It works wonderfully. It really does. It had a tremendous amount of success. I think 50 plus graduates in the 3 years that I was on therapeutic court. It's absolutely amazing to watch. In terms of extending that, we've extended that to mental health. So we have a mental health court, which helps people that have committed crimes because of mental health issues. So we get them into mental health treatment, just like we would get them into drug treatment if that was their issue. In terms of domestic violence, it doesn't quite work that way. I want to be very circumspect here and very careful because, again, as I referenced earlier, judges aren't supposed to take a position on policy, and that's sort of a policy thing. I'm going to leave that to the legislature, how they want to deal with domestic violence abusers, domestic violence perpetrators. That's not my role. That's certainly not my job. That's above my pay grade, so to speak. But I will say this. We do know statistically that domestic violence treatment is far less effective than other forms of treatment. Drug treatment, mental health treatment, those have a far higher success rate. Domestic violence has a very low success rate in terms of domestic violence treatment. So do I think there should be a domestic violence court? I don't know. We don't have one now. I don't know of any discussion to start one. I don't think there will be one. I think it's problematic. I mean, it's certainly a good idea, but I don't think it would work in practice. Thank you very much.
I think it'd actually be an interesting thing to think about. I mean, King County does it, Spokane County does it, several jurisdictions within the state do it. Oftentimes it will be at the district court level, and I understand that philosophy kind of start off with maybe some less serious domestic violence conduct as opposed to felony level superior court. DV conduct can be much more dangerous and usually maybe has a longer track record perhaps. But I think the drug court model actually could work in domestic violence situations because of the drug court model. I have been a part of drug courts in various jurisdictions for a long time. And in Grays Harbor County, I've referred many of the defendants in my cases to whether it be which branch of the therapeutic court, mental health or drug court. I believe in it. And I believe in it because of the model, the objective assessment process, the high level of judicial involvement that occurs, the graduated punishments that occur, the very intense supervision and monitoring of these people. So I think domestic violence is just such a terrible thing that's pervasive in our community, and it repeats itself generationally. And so whatever we can do to try to stop that, if the drug court model can be morphed, and it is being morphed, into addressing domestic violence concerns, I'm all for it. Domestic violence needs to be addressed as aggressively in a way to prevent recidivism as possible. And if the bench can be a part of that, King County, Spokane County think it's a good idea, I'm willing to take a look at it. Thank you.
Thank you. How do you,
Turn the mic up.
no, it's not there. Did you? How do all Superior Court judges should be paid the same regardless of local cost of living and/or caseload?
Gosh, I hadn't really thought about that. Everyone's always just told me what I'm gonna make when I apply for a job. I haven't had much say in it. But, you know, I think wages throughout the state for public servants, they vary in regards to the costs and property values and such. So I think it's okay if the commissioners of the state, when doing their budget, they determine that it's, that we live in an expensive area, if we do. I'm not saying this is an expensive area. This is the cost of living in this area, and this is what the appropriate pay should be. I don't know about paying, for instance, I guess the question would be a judge in King County the same as a judge in Ponderay County. Or, you know, it's just such a different cost of living. It seems to make sense that there's some variables there that are taken into consideration by the commissioners of those respective places and make the decision to pay the folks what they need to be paid and deserve to be paid in that particular area. Thank you.
All right, so I am going to first admit right up front that this is obviously not an area of our expertise, mine either. So again, above my pay grade, but I will tell you, I do have some understanding of the system. So the legislature actually sets our salary. So you can actually look up our salary. It's literally set by statute, and it's the same for every judge in the state. We all make the same amount, based on court level. So all Superior Court judges make the same, all District Court judges make the same, all Municipal Court judges make the same. It's all set. And in order for that to change, we have what's called the Salary Commission. And it's a commission that gets together and makes recommendations to the legislature about what our pay should be. So for example, we did have a recent pay raise. I think there's been 2 since I took office in 2018. Small ones, but so occasionally they do meet, the Salary Commission meets, and they discuss the cost of living, just like in any other profession, right? Costs go up, pay is supposed to go up in theory. And so they meet and they discuss it and they figure out whether our pay should be increased. I mean, I don't really have much to say beyond that. I mean, I think the system that they have now, it makes sense, other than I would say, as I think my colleague also said, that it doesn't make a lot of sense for a judge in King County to make the same as we do here, because obviously in King County, the cost of living is way higher. So do I think that's a good system? I don't know. But that is the system that we have. Thank you very much.
How do you, I do know how to speak in a complete sentence, but it's not worth it if it's not working.
Don't worry, I'll cut it out.
Okay. How do you hold ethical standards in your courtroom, and what mechanisms do you believe should be in place to hold judges accountable for misconduct?
Yeah, so it's not a matter of what I think, it's a matter of what I know, which is that there is a whole entire system set up. So there's actually the Judicial Conduct Commission, and that's made up of some attorneys and some people that are not attorneys, and it's like a coalition of different individuals that are appointed. And they serve on this commission, and what they do, their responsibility is to receive any complaints against judges, and then they evaluate those complaints and determine what response to give. In terms of ethics, we have what's called the canons of ethics. So we have a book, And if you go to the book, it'll tell you, here are the rules, right? So if you read them and you're familiar with them, right, then you follow them. I mean, it's simple. It's like any other system. If you break the rules, there's going to be consequences. Sometimes people choose not to report, as I've done. I've chosen not to make complaints to the Judicial Conduct Commission for the conduct that I've witnessed and that I've seen. I choose not to do that. It's not mandatory. It's certainly discretionary. It's optional. I'm under no obligation to make such reports. And quite frankly, I think in a campaign of this nature, I think it's probably best not to do that. And also, too, it's difficult because a lot of times there's no teeth. So even when they receive a complaint and the complaint is sustained against the judge, the response is often pretty lackluster, to be honest. I mean, if you look at the sustained judicial conduct complaints, the punishment for those violations are usually not very significant, to be perfectly honest. It's not something I have to worry about or think about because I've never had a complaint. Never had a judicial conduct complaint, sustained or otherwise, so it's not something that I necessarily think about. Ethics to me are a given. I mean, I don't have to think about it. It's not a challenge for me. I know the ethical rules and I follow them. It's just that simple. Thank you.
Well, I would agree that generally these rules are set in place. They're clear. They're for everybody, all the judges to know. So that part of it's not very fluid. I would suggest that, your ethics begin with you as a person. No one's above the law, certainly. We all, as a judge, judges need to be responsible. They need to be accountable for their decisions. They need to have that ethical standard in their personal life as they do in their professional life. Judges are held to a higher standard. I would suggest that prosecutors are too, and all public servants are generally too. But as you look at the breadth and spectrum of public servants, probably judges should be held to the highest standards of ethical consideration. So, you start off by being an ethical person. You're doing your best, listening, respecting people, respecting the participants, allowing people to be heard, respecting their time. And then it will flow from there. You have the guidelines always, but if you really have to go back to the guidelines to make sure that you're doing the right thing, well, perhaps you do sometimes, but generally, I think all of us know when we're playing by the rules, and I would suggest that most of us probably know when we're not.
Thank you. Do you accept all aspects of code and judicial conduct? And if not, what would you like to see changed?
Well, as has been pointed out here tonight, and I'm not shying away from it because it's the truth, I've been a lawyer for a long time, I've been a prosecutor for a long time, I haven't been a judge. That's okay. So I'm not out to change the canons, I'm not out to change the rules. I'm here to follow the rules, I'll follow the rules. So I'm not going to be my emphasis when I become a judge is not going to be to change the framework, change the hard work that everyone's put in to establish these canons, to establish these rules. I'll be there to follow the rules, but my emphasis will be in learning subject matter, in listening, in preparing. I think I'll just, like I've done really my life, I've led by example, and I would try to continue to do that. So no, I'm not out to change the rules or change the canons. They are what they are. They've been that way for a long time, and I would suggest that they're just fine the way they are.
Yeah, I will say this, the rules, is that better? No. Not on. Okay. Let's see what's going on here. It might, because it says it's on. It might be. There we go. All right. So the rules are voluminous. I mean, there are a lot of rules, and most of them, if not all of them, have a very good reason, right? There's obviously something happened, and that's how rules are created, right? So I'm not wouldn't necessarily advocate for changing them because I think all the rules that currently exist have a purpose and they have a place. I am a little dismayed with the rules surrounding campaigning. I think the rules could be more clear. I think they should be more clear about what you can do as a campaigner, as a candidate, not a sitting judge, but a candidate in a judicial race. That should be clear. That would be helpful. Also, campaign finance. I'll let everybody know here, full disclosure, I have not asked any single person for a penny. I have self-financed my entire campaign as I did the last time and the time before that. And the reason why I do that is because I think pandering for money and asking people for money is problematic. Not for politicians, certainly not, right? Republican, Democrat, no problem. But when you're a judge, you shouldn't be going around asking for money. That's a bad look. And there are very strict rules actually about that. In fact, believe it or not, our Supreme Court, one of our Supreme Court judges, Mary Yu, she actually got a sustained complaint because she was seeking charitable contributions. I mean, it wasn't even for her. She was seeking contributions to a charitable organization, and she got a complaint against her, a sustained complaint. And she actually got reprimanded, sanctioned or whatever. So that maybe is a little absurd, I think. That example kind of takes it a little bit too far. But I do think it's a good principle to say we shouldn't be going around asking people for money any more than we should be asking people that are highly partisan to endorse us or to affiliate with highly partisan individuals. That's a mistake. That's a mistake, and I think it erodes the public confidence in the judicial system and in judges. And I think that should be clearly stated. Thank you very much.
Thank you. There is,
I guess I need to have both hands on this mic, on both mics to keep them working. The question is, have you ever been arrested? And if so, why?
All right, well, I figured this was going to come up. I can tell you that up until February of this year, I can honestly say no. Never been arrested, never had any issue. There was a very unfortunate incident, and I'm not going to run from it, hide from it. Full disclosure. I was arrested in February of this year. Falsely arrested and ultimately not charged. I was suspected of a DUI, which in the end, I cooperated. I took a breath test, and it was .01. That's 1/2 of one drink. It's 1/8 the legal limit, not under the influence. But the fact is, I was arrested, and wrongfully, albeit, but I was arrested. So full disclosure, that did occur. I would encourage anybody who's going to rely on that information or consider that when they vote, I would urge people to go look at the actual official report of that. It's very enlightening. What it reflects is that there was no reason for me to be pulled over, no reason for me to be arrested. When I took a breath test and it was .01 and I was released without charges, rightly so. These things happen, right? And actually, if anything, it's actually kind of a positive in my view, because it really helps me to understand the plight of someone who is wrongfully accused, because we know this happens, right? We know people get wrongfully accused, they get wrongfully convicted, it happens. You can't turn a blind eye to that. So now I have that experience. I can honestly say that I've been through the process, so to speak. It wasn't fun, it wasn't particularly pleasant, I will tell you that. But I'm not embarrassed about it because really, in the end of the day, the truth is, I didn't do anything wrong. I didn't do anything wrong, so it is what it is. It was an unfortunate incident, but again, I would encourage anybody who has a question about that, and I'm happy to answer those questions as well, by the way, but I would encourage anybody to look at the official report, and it will tell the story. But that's pretty much all I have to say. Thank you.
thank you.
No, I've never been arrested for anything. So it's interesting, the role that you have as voters is critical. It's similar to a jury. I'm asking for your vote as I would ask in some fashion for finding of guilt at a trial. So it's very important to have that voice, to have that vote. And so when you make your vote, it should be to the one who's accountable for their actions. So my opponent talks about it in a fashion where he's kind of playing the victim, frankly, to the situation. And I'm not going to speak to the merits of this arrest. I'm not going to do that. But it is a problem when you say, do you know who I am, to a police officer? And you're a judge, or you're a prosecutor, or you're someone of importance. It's a problem. It's using that influence in a fashion that would seek to change the actions that are happening. And so it's about being accountable. You know, this whole race is really about accountability. Now that he has an opponent, he has to be accountable for his behavior. And I'm not hearing that tonight. I'm hearing a defense attorney doing a cross-examination or attempting to, or a closing argument to a jury, trying to get their client off, over speaking, talking quite directly and incessantly, repeating some phrases now and again. Do you want a defense attorney as your judge? That's the question you need to ask.
Shame on you, Steve. You know that's a lie. That's a lie, and you know that's a lie. You know I didn't say anything of that sort to the police. That is a blatant lie, and do you want a candidate that's going to blatantly come up here and lie and make a materially misleading and false statement? You do not want a candidate of that. I implore you, now I'm going to insist. Go to the report. You're going to see he just lied. He literally just lied about what I said to the police. It's incredible. I cannot believe I am up here on stage with this gentleman who wants to lie to you to get votes. It's absolutely deplorable. It's deplorable.
Another question is that if you are an attorney, or if you're a judge hearing cases from lawyers from your previous firm, how do you convey that you are,
Sorry about this. How do you convey that you are impartial and that you are being fair to people that you worked with currently or in the past? And how does that go towards appearance of fairness?
Me first?
yes.
Perfect, okay. Yeah, that's actually a really good question. So there are ethical rules surrounding that exact issue. And so full disclosure, transparency, again, that's the key. The key to avoiding ethical quagmires, if you will, is to be upfront. And so there's full disclosure. So for example, if an attorney from my former law firm, and I was with a law firm in Aberdeen, a very well-known and well-respected law firm for a number of years, 13 years. And it's a small legal community. Grace Harbor is a very small legal community, and it's inevitable that you're going to have lawyers from your former firm appear in front of you, and that's happened. That's happened with me. It's happened on a number of occasions. The difference is that you have disclosure. So you disclose it, you offer to recuse yourself if there's a conflict. If it's a case where you have a conflict, you recuse yourself. If there's a case where it appears you might have a conflict, you recuse yourself. It's really simple. It's not complicated. And that's a case-by-case analysis. So just because you have an attorney who you used to work with appear in front of you doesn't mean that doesn't make it a conflict. That doesn't necessarily make it a conflict. It's if you're handling a case that existed when you were an attorney. So for example, if I represented John Smith and then I left law practice and an attorney from my old firm came up and wanted me to hear the case about John Smith, I would say, yeah, I can't do that. Can't hear that case because I was an attorney in the firm when that person was a client in the firm. That's a conflict. Clear conflict, no question. I step back happily, recuse myself. So there's certainly a procedure and a method, there's a way that you deal with those situations, and you deal with them appropriately. And like I said, I'm proud of my record. I've never had anyone accuse me of having a bias or being anything other than impartial. I've never had a complaint, never had an ethical complaint of any kind against me. So I think that speaks for itself. Thank you very much.
Okay.
Well, this isn't a situation that I really are involved in directly, certainly. I've represented either way back defendants, or I've represented the state. So I don't have these types of situations, and I wouldn't have. I don't have many close friends, and I would disclose certainly any types of relationships that were too close. For instance, I think I'll have to stay off the criminal docket for probably upwards of a year, just to kind of, certainly to wash through all the cases, so I'm not familiar with any of the facts as a part of my job, but with relationships too. So always, transparency is definitely the way to go. But also it's the appearance of this, so my opponent, still hears the cases of his former firm when they occur, and, of clients that he had clients before with that firm. It's the appearance of the impropriety that is the most important thing. It's not some conclusory statement by a self-interested person saying that there's no conflict here, or a disclosure, which generally happens with my observations of, specifically, it's Mr. Kupka, who comes into our courtroom quite often, affable fellow, a good attorney, used to work with Mr. Mistachkin. It's the appearance, and that's, when you talk about transparency, it's about the appearance. So I would suggest that in those situations where he's dealing with former partners, it's probably not the best idea to hear their cases.
How would you improve access to justice?
Well, it's an interesting thing, like during the COVID thing, I mean, we had the birth of Teams and Zoom, really, and now it's a part of our lives, especially in the professional world. It was a difficult transition, certainly, for someone that was always appearing in the courtroom, to be at a desk and to look at a monitor and manipulate monitors and be able to figure out what's going on and share a document if you have to do those types of things. But, growing pains are tough. I guess they're a little tougher the older you get. But now we're seeing that, it can be an incredibly effective tool. It allows access to the courts for the participants when it's allowed. We also showed during the COVID period of time, we put the hearings on YouTube. And I actually thought that was a wonderful idea. And I would kind of go back to that and see if that was ripe again. Because what it does, it allows people that live far away, out here in the shores, you're half hour from, or more, from Montesino Court. You can turn on the Zoom and you can watch a hearing. You're not going to drive in inclement weather. You're not dealing with potential health issues or lack of transportation. Yet you still have that access to the courts. You have that access to the system. Everyone should have access. You shouldn't have to have a car. Shouldn't have to be healthy. Shouldn't have to have the time to go to a hearing in order to have that hearing, the knowledge of what happens at that hearing. You should be able to turn on the computer or the phone, look on your YouTube and watch that hearing. There's no reason to restrict access at all. And I would seek to kind of go back there and see if we could start that up again.
Thank you.
Yeah, that's a really interesting question. So when we talk about access to justice, we're not really talking about just being able to watch court proceedings, right? That's what that really is geared towards, is people that have low financial means and they don't have the ability to hire an attorney. That's the quintessential problem of access to justice. And so in my law practice, one thing I did personally was pro bono work. So I gave away thousands and thousands of dollars of free legal help. And I did it because some people needed it and they didn't have the money. And so you just kind of share the wealth. So I did that. That was a very routine practice. And I have encouraged other attorneys to do the same. There's also, we created, my benchmates and I, since I've been on the bench, we created what's called the Grays Harbor Self-Help Center. I don't know if anybody's heard of it. It's in Montesino. It's right down the street from the courthouse. It's a fantastic program. It's actually a pilot program. Only 2 counties in the state got it, Spokane County and Grays Harbor County. It's fantastic. So it's fully funded, and it allows people to go in there and actually get help with their legal issues. They can get help with filling out the forms. They can get help with instructions on how to file, how to proceed with their case, how to bring it all the way from start to finish. It's fantastic. I mean, and it works. It's worked wonders. I've done some work with some of the civil legal aid organizations. Those are organizations like Northwest Justice Project, for example, which we also have locally. And they do either pro bono or low bono, meaning low charge, based on a sliding scale, based on the person's income. And those type of programs, which I'm a big believer in, they help people that don't have the means to hire an attorney get their legal case heard. Because a lot of people, if they don't have an attorney, they don't know what to do, and they just give up, and they don't pursue their legal matter. And that's what we're really talking about with access to justice. It's critically important that we promote people's ability to access the law and access the courts. Thank you very much.
Thank you.
What is the most important characteristic that you bring to the bench?
Hard work, I would say. Private practice is no picnic. Private practice is a eat what you kill proposition, meaning that you don't get paid unless you work. So I had a culture in our law firm, in my law practice, of working very hard, right? Because let's face it, being an attorney is a volume business. It is, like anything else. So I am geared to work hard, and I do work hard, and my work ethic is, I don't want to toot my own horn, but I work very hard, tirelessly, and I will continue to do that because I believe in the work. And that's what it comes down to. If you believe in the work, you work hard, and being in good faith. I would say good faith is the other part of it. If you want to do a good job, and you're conscientious, so conscientiousness was another one. If you're conscientious and you work hard, that's a formula for success. And that's what I bring to the table. Thank you very much.
And I think I turned that off.
Well, if I had to pick a single thing, I would say balance. I'm the candidate who's done both sides of the criminal justice side. I've done the public defense, I've done the prosecuting. And that allows me the balance and knowledge on kind of what people may be thinking within the process. So I understand the concerns of the defendant that may have an impact to their family. I understand certainly the need to protect their rights as they make their way through the criminal justice system. As a prosecutor, I understand the plight of a victim because I meet with them all the time. I meet with victims in every one of my cases that if they've provided the correct contact information. So I understand the kind of the roles that all the participants have because I've done both sides of it. My opponent's just done the defense work, and I hear he was a good defense attorney. I'm seeing some of that tonight. But he doesn't understand what it's like to be a prosecutor. He makes a finding in the criminal cases that it's in the interest of prosecutorial discretion, but he doesn't understand that. He doesn't understand what it means to talk to a victim of sexual abuse, to talk to a domestic violence victim, to work with them. He doesn't understand what really goes into an investigation on the police side except to attack it from a defense side. Talk to any police officers. Ask them who they're voting for.
Thank you. We're going to go ahead and give you 3 minutes to close. And Steve, you're up. Since I have my hand on your mic.
Well, this has been a fascinating process. It's been a difficult process. As you may be able to tell, I'm not the polished public speaker that I'd like to be. I tried to choose my words. I tried to impart what I'm trying to impart to you, but I haven't done this before. I know I have been disparaged tonight. It's okay. It doesn't hurt me. Strong language has been used tonight, whether it be impugning or fascinating thing happened at the very beginning of this process. I put in right at the end. And when I put in, I promptly heard from the opponent by text message. And he wanted to know why I didn't run against the more vulnerable candidate, Judge Samuel, his colleague. I found that fascinating. And it began a process over the next couple of weeks where he came into after I went to a hearing to watch one of my colleagues in a 3 strikes hearing. And he was a younger attorney, so I wanted to make sure everything was going okay. And I was sitting in the gallery, because I was supervisor, I was chief at the time. And we went downstairs. I didn't think there was much to do about it. My opponent comes down, and all of a sudden he's in this private prosecutorial area, which I have seldom seen a judge appear. And he demanded to speak with me. And so I was new to the process, but I knew you're not supposed to talk about this stuff in the courtroom. And so I agreed to walk around the block with him. And it turned into a matter of, I've got the money, I've got the machine, why are you running against me? Very demanding. It was the defense attorney coming out. It was insecurity coming out. And so what this comes down to now is the time of the voters to speak. I think he's realizing that now he is accountable to the voters. There is an opponent. He has to answer for things. Not in these broad brush, tooting the horn type of things, but actually to talk about some of the concerns that the citizens of Grace Harbor have about him. I don't have such baggage. I am a public servant, and I will always be a public servant, and I'm ready to be the judge here in Grace Harbor County. I'm ready to elevate the level of respect and integrity and accountability. I will be accountable. If I win and I have an opponent in the future, good for the voters, good for everybody. Then there's a choice. This isn't a king. This isn't a king who will ride out the judicial career until they want to leave. No, this is up for review every 4 years. Accountability is key. It's your turn. I thank you for your vote this November.
Thank you. Go ahead.
All right, first I want to thank everybody for being here and listening to us. I know everybody's probably got other things they'd rather be doing right now, and I agree, this is very important to discuss these issues. But also, we need to limit it to relevant issues, right? And so, a lot of what we've heard from Mr. Jackson's side in campaign is really just noise. It's not relevant. So I want to bring us back, because all this back and forth that you've heard might be confusing. He refers to all these problems people have with me, but he doesn't cite a specific person or a specific example, not one. You notice that? He didn't cite a specific person that has a problem with me. He didn't cite a specific example where I made a mistake on the bench or I did something improper or inappropriate. Nothing. He's just making these statements. He's just hurling these insults at me, but it's okay, because it helps me bring into focus what's really important. And you know what's really important? Experience. I'm going to bring it right back to what I've always said. He wants to hide from it, he wants to run from it, but there is no getting away from the truth. This is a job that requires appropriate experience, and I have it, and he doesn't. It's that simple. That's the beginning and the end of the analysis. I've been a judge for 8 years, and I've done a great job. And I think people think I've done a great job, and I'm not sure who he's referring to, but if you talk to the clerks, the court administrators, people in the justice system, people out in the community, you'll find that people have a pretty favorable opinion of me and the work that I've done. And I've worked very hard. I've worked hard to earn that, and I'm proud of that reputation. I've earned that reputation, and I want to continue the work that I've done on the Superior Court bench. And I would urge caution. If you're considering voting for Mr. Jackson, just look at his background. He's been a prosecutor only. He has no other experience, not really. And he's not from Grace Harbor. He's not here. He hasn't been here. He's been here for a few years. So I'm not sure who he's talking about. You say all these people know him and support him. I don't know who he's talking about, other than some of the police officers he works with as a prosecutor, which makes sense. But other than that, he doesn't have much going on. And there's a reason for that, because he doesn't have the experience, the depth of experience necessary to do this job. He's just simply not qualified. I mean, that is the bottom line. He's unqualified for this job, and I urge you, before you consider voting for him, just to take a close look at his background and his experience. Compare it to mine, that's all I'm asking. Compare my experience to his experience, that's all. And then make your vote based on that. Thank you.
It's been a difficult time. We actually went through quite a few cards, so I thank you for the participation. And I have to thank the candidates. Normally I ask if, when you run for election again, that you take my call, but I think that I don't want it to seem improper when it comes to a judge. So I'm hoping that we clear it, that I would be inviting you back for a forum. And it's difficult to run for as a candidate, and so I appreciate both of you coming and being willing to work for us. Thank you. And this will be put up on YouTube, and we'll let you know when it is uploaded. And thank you for coming, everybody.
Thank you.
Thank you, Gina.
Thank you.